Good morning. The uh, general exception plays vital role during criminal trials, particularly for the offences punishable under Indian Penal Code. There are two categories of general exception. Generally, the court may straight away say that if you plead general exception, they may say it is burden on you, but that is not a straight jacket formula or policy, because general exception two in kind fundamental general exception, because since if that applies, the ab initio trial commencement itself is invalid. Then the question arises defense general exception. General exception for defense, then burden shifts on the accused to prove is. And initial burden is the prosecution must prove that the accused has committed the offence with mens rea. So all these things is most important. For fundamental general exception is act of God, accident, and offence committed by the child below 7 years. These things are fundamental defense, fundamental general exception. So you cannot lay charge sheet for this. If other exceptions, defense exceptions are triplically private defense and insanity, involuntary intoxication, etc., etc. Okay, this judgment deals with such a fantastic concept and subject. AR 2025 Supreme Court 3291. AR 2025 Supreme Court 3291. Dasrath Patra versus State of Chhattisgarh. See, actually, what had happened, the accused seems to have assaulted and caused death of a person, and that had happened. That is date important. That had happened 2018 September 27th September 2018. But the prosecution did not sought for medical examination accused to prove that he was not insane during the time of occurrence. But thereafter what had happened, then they went to High Court on appeal. High Court 2023 seems to have called for medical examination. Since the medical examination declared negative about his insanity, they have confirmed the sentence. But the Supreme Court has now, as by referring the judgment of Dayabai Chandanbai Thakur, this is AAR 2000, this is 2023 9 SCC 739. There they have guidelined following proposition that prosecution must prove beyond reasonable doubt that the accused had committed the offence with the request mens rea, and the burden of proving that always rests on the prosecution from the beginning to the end of the trial. Then there is a rebuttable presumption that accused was not insane when he committed crime. The sentence laid down section 84 of the accused may rebut it by placing before the court all the relevant evidence, oral, documentary, and other things. Then third question, even if the accused was not able to establish conclusively that he was insane at the time of he committed the offence, the evidence placed before the court by the accused or by the prosecution may raise reasonable doubt in the mind of the court as regards one or more ingredients of the offence, including mens rea of the accused, and that in case court would be entitled to accuse the accused on the ground of the general burden of proving resting of the prosecution was not discharged. So here they simply said the accused killed with iron pipe. Prosecution witness admitted that he was insane and he used to fight with the villagers, and all the other witnesses are there. But the prosecution failed to send him for medical examination during the time of trial. Sending him medical examination during pendency of appeal is not legally sustainable because of lapse of years. Therefore, they have acquitted him. Go through the judgment. Best wishes.